I am so honored to be here today. I'm also honored that I was on the Executive Council for AARP for 5 years. It was such a wonderful, wonderful experience. So the name of this talk today is Be Proactive and Be Prepared. If you're in real estate, the motto is location, location, location. But with what I do, it's plan, 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 and plan ahead. So whatever you take from this, plan ahead. By the way, I'm going through a lot of material. Here's my bio. But if anybody wants the slides, feel free to go to, we have a table here. See Jackie, just give her your email address. She's happy to email you the slides. So when you want to be proactive and you want to move ahead and make sure you have everything in place, the first thing you have to do is get your team together. You want to have a good team. When you know what hits the fan, you want to make sure you could just pick up the phone and get the information you need. So number one, since this is my focus, you want a very good attorney that specializes, that handles elder law or trusts and estates. You want somebody that knows the nuances. Many people think, oh, a trust is a trust. You could download it. It is so different than that. Every trust is different. You have to know the nuances. That's where the details are. In order for the trust to be successful, the details have to be in that trust. And we're going to go over what a trust is. I can't tell you how many clients come into my office and say, Mr. Fatoullah, I want a living trust. I said, okay, why? He said, I don't know. A friend of mine had it and things worked out so well. Do you know what a living trust is? Not exactly. So today, you're going to understand and know the documents that everyone should have as they age. Anyone over 50 should have documents as you age, and we're going to let you know what these documents are. More importantly, we're going to let you know why. The why is very, very important, because once you know the why, it's going to stick in your brain. So the why is very important. Anyway, getting back to getting your team together, you want the attorney. The attorney drafts documents. The attorney's like the quarterback. We'll do the elder care planning, the estate planning, the estate tax planning. Make sure that your assets are held with the right entity. It's very important. Oops, let me just get this. Okay, I'm not sure how to get that all. There we go. The next individual or individuals is the financial advisor. Don't think that the financial advisor is not important, because the financial advisor has to manage the assets. Let's say we create a trust for you, and you have this trust. Someone's got to manage the assets in that trust. If the assets that are managed in that trust are not managed in the right way, you could lose the protections in that trust. For Medicaid, there's a little slight tweak. This has happened just a couple of weeks ago with a client of mine who became a client after the fact. The trust was, assets in the trust were distributed in the wrong way. And all of the assets in our Medicaid Asset Protection Trust were available for Medicaid. We were past the 5-year look back, a little minor detail, but it meant everything. So you got to be very careful. You want a good financial advisor that understands. If that financial advisor is managing assets in a trust, that advisor has to know every detail of that trust. So many times when we set up a trust and a client has a financial advisor, I want to speak to that financial advisor. I want to make sure that financial advisor understands how the assets must be distributed, how the assets should be managed. Next, of course, you want to have a good tax, an accountant or a CPA, very crucial. And as you get older, things happen to us. Even if you don't need a geriatric care manager now, you want to think about getting someone just so you have a couple of names to call if you need that kind of care in the future. Okay, so let's talk about the 5 most important documents you need as you age. Sorry, that was my son. We'll take it later. Number 1, last will and testament. Everyone knows last will and testament is a document that sets forth where your assets go when you pass away. But some people don't know that it doesn't cover all your assets. The last will and testament does not cover any assets in a living trust. The last will and testament does not cover any assets that have a beneficiary designated on those assets. We're going to talk about a power of attorney, where you appoint someone else while you're well, while you could sign the document. You want a good, broad, expanded estate planning, elder care, power of attorney, not just a form you download. You want a good power of attorney so that if something happens to you, should you become incapacitated, you cherry-picked, you name someone that knows what you want and someone that you trust implicitly to manage your affairs. So the family does not have to go to court and get a guardian appointed for you. Even if your husband and wife, just because you have a spouse doesn't mean they could just take over for you. You said, I do, but it doesn't mean they could do anything and everything. Healthcare proxy, that you don't need an attorney for. But a healthcare proxy is where you set forth, you name someone to make your healthcare decisions for you if you can't make them. Pretty simple. You don't need a lawyer for this document. You need to tweak it a little bit, and I want to go over with you today just the little tweaks so you could just download it, sign it in front of 2 witnesses, and have it. Very essential. Living will sets forth what your healthcare wishes are. Last will and testament, where your assets go. Living will, while you're living, you set forth what your healthcare wishes are. You don't want to be kept alive artificially if there's no chance of recovery, you put it down. If you do want to be kept alive artificially, that's okay, put it down. We have a lot of clients that are on ice. They passed away. They signed up for cryogenics. Anyone ever hear of that? Ted Williams, baseball player, he's on ice. So, you know, it's legal. You could sign up for it. But you want to make sure when you have a healthcare proxy, when you name someone, you want to make sure they know what you want. What do you want to have done with your body? And a living will is a great document for that. And a living trust is crucial. It's crucial for almost anyone that has any real estate, a co-op, any assets. You want to make sure that those assets are held properly. And the last bullet point, I just want you to know, these documents are yours. As people age and individuals might become a little more frail mentally, still lucid and could be vibrant, but a little more frail, and family members, others, could try to influence you. Never, ever be influenced. These are your documents, and you should get exactly what you want. Okay, let's go over the will in a little more detail. I have about a half an hour, so I'm going to be going pretty quickly, but again, if you want these slides, they're available to you. So again, a will sets forth where your assets go when you pass away. The individual that creates the will is called the testator. In the will, the testator, you, will name an executor. Who's going to manage these assets when you pass away? And you name beneficiaries. Who could be a beneficiary? An individual, a charity, but people oftentimes don't realize a trust could be in the will. Remember Leona Helmsley? She left millions and millions of dollars to her dog. Dog's name was Trouble. And Trouble had millions of dollars held for this dog. Well, in the will, did the executor just give Trouble money? No, it was held in a trust for the dog. So trusts are in the will all the time. And one of the major provisions in almost every will that we have would be a minor provision. You know, many times my clients don't want individuals when they turn 18 to get a lot of money or even a little bit of money. They're not mature enough. So we have minor provisions that might say, oh, grandchildren, or if a child dies, their assets go to their children. They don't get it, but at age maybe 21, they get a third. 25, another third, and 30, possibly another third, or any other way that you want to do it. Many people question, could the executor that you name be a beneficiary? Of course. Let's say you have one child, and you want that child to be the executor and the beneficiary. Certainly nothing wrong with that. Now, is there anyone that you can leave out on a will? The answer is no. You could do whatever you want. You want to leave out a child? No worries. You want to leave out a spouse? No worries. But look at the last bullet point. In New York State, we have something called the right of election. If you are a spouse at the time of death and you are not given at least the greater of $50,000 or 1/3 of the estate, you go to court and say, look, I didn't get 1/3 of my husband's estate. At $600,000, I'm entitled to a minimum of $200,000. You don't have to show you need that money. You just have to show that at the time he passed away or she passed away, you were married. That's all. You should know if you don't have a trust and you don't have a will and you don't have beneficiaries that are named, then where do your assets go? New York State has a schedule that sets forth that family members get. You know, if there is no will, no trust, no beneficiaries designated, there's a whole schedule. But it may not be what you want. So, for example, if there's a spouse and no children, everything to the spouse. If there are children and no spouse, everything to the children equally. What if you're estranged from a child? Too bad, you should have had a will or a trust. What if there's a spouse and children? Well, the spouse gets $50,000 and 1/2, and the children get another half. Now, if I were a spouse relying on my wife's assets, you know, when she passed away, and I'm only getting half of them, I would be very ticked off, you know. So make sure that you have a will, a spouse has a will, even your children should have a will. Everyone should have a will. And you don't want New York State, in essence, to write your will for you. Write it yourself. And if you feel that someone might contest your will, we would draft the will a little differently. Now, who could contest your will? Can I contest your will? No, because I have nothing to do with it. But anyone who would get, if there were no will, can contest your will. So it's always a spouse, always a child. But nobody could contest because they don't like what you said. They could contest, though, if the will wasn't signed right, if the person that was signing the will didn't have enough capacity to sign the will, or if there was fraud or undue influence. Okay, so there are ways that we could eliminate or at least lessen the chance of a will contest. And one way is to have a living trust. Living trust is a much safer bet, especially if you feel that someone may contest. Okay, so let's move to the next document, power of attorney in New York State. You might Google it and say, oh, there are powers of attorneys for healthcare decision-making. Look at this, finding all of this on Google and ChatGPT. Yes, but not in New York. In New York, a power of attorney is only for financial matters. But when you're over 50, as you age, you want to make sure that you have more than just the basics. You want to make sure that if something happens to you where you don't have capacity any longer, the people that you picked, or the child, or best friend, or anyone that you trust implicitly will do the right thing and not have the family go to court and have a guardian appointed. Now, with the power of attorney, let's say you have 3 children, you want to name all 3. Can you do it on a power of attorney? Absolutely. You could name all 3 children. And you could even specify they could act separately or they could act together. So some people say, oh, I want them to act together. That is so great. They're going to talk to each other, and life is wonderful. When you have 3 children with 3 ideas, look, I have 2 children, same parents. They're like night and day. I love them both. But if you're going to name 3 people to act together and you need all 3, nothing's going to get done. So you want to think about this, but you can do that. You can do that if you want, and we could even specify 2 out of 3, or at least 2, or however you want to do it. But you want an expanded power of attorney, because if you don't have capacity and the window shuts, the window of capacity shuts, then you can't sign this document any longer. And then what? So you really want a good power of attorney, and you want to name, if you just name one, you want a successor, probably a couple of successors, just to be safe. So that's very important. Now, signing requirements on a power of attorney: 2 witnesses and a notary, and one of the witnesses can be the notary. But again, I urge you, don't download the form. It's just not good enough. It's good enough for a closing, but as you age, you want estate planning provisions in there, such as the ability to create a trust. We were talking about trust. To revoke a trust. Things change. To amend a trust. You want that. We put Medicaid provisions in it. Intent to return home to protect your home. And the list goes on and on. We might put in 40 extra provisions. Make sure you see an elder law attorney to do that. Now, used to be until a couple of years ago, you have a great power of attorney, you go to the bank, and the banker says, you know, to the agent of the power of attorney, you want to take money out, and I'm looking at a ratty piece of paper, and, no, we're not going to do it. And if they said no in the past, there was no liability. There was no teeth. Now we have teeth. The law changed a few years ago and said that if you present that power of attorney to the bank or the brokerage house, and they say, yes, it's fine, and we're going to do what you want, great. But if they say, no, we're not going to accept it, they have to have a good reason. Now they're going to be liable. And what if we're talking about a Medicaid look back and the cost of a nursing home is $20,000 a month, and they're delaying us by 10 months for the nonsense? Well, they're going to be liable for $200,000. So now, if you present the power of attorney and they say, no, we're not going to accept it, they have to do that in writing to the principal and the people that you name, the agents, have to do that in writing within 10 days. And then, whenever you respond, you say why the power of attorney is good. They have 7 days to respond. If they still don't accept it, and the court says it's a good power, they are going to be liable. So we do have teeth now. Okay, and I did say that that's not a DIY document, a do-it-yourself document, but we do have the healthcare proxy, and that is a document that you could and should do on your own, or we do it for our clients. We do tweak it a little bit, but I'm going to give you all that information right now. Healthcare proxy is where you appoint someone else to make your healthcare decisions. So you're going to appoint an individual. It could be a spouse, it could be a child, anyone who's over 18 years of age. It's an appointing document. Remember I spoke about a living will before, where you set forth what your healthcare wishes are? Living will is not an appointing document. You're just saying what your wishes are. But the healthcare proxy is recognized. It's in the law, and you could just download it. So if you Google New York State statutory healthcare proxy, download the form. It's very simple to fill out. But this law came about in 1991, and the doctors and hospitals lobbied. They just wanted one voice to deal with. So they said, well, you can only name one individual at a time. Remember with the power of attorney, I said you could name a bunch of people. You could have 3 children together, 4 children together. But with the, sorry, let me just, okay, that won't happen again. With the healthcare proxy, just one person at a time. So if you want to name spouse, then child A, then child B, but there's only one voice. And it only takes effect when you can't make your own decisions. And again, you need 2 witnesses. You don't need a notary. Very simple to do. And you don't want any of the witnesses to be anyone that you name to make your healthcare decisions. I think that's obvious. And you don't need a notary. Very important. Now, well, let me backtrack on this. So in the healthcare proxy, it's very self-explanatory. They even just guide you, the law guides you on how to fill it out. But there's one part of it that says optional instructions, and you want to make sure that you make it very clear that you want your agent to make decisions about feeding tubes, whether you want them or don't want them, because you have to show by clear and convincing evidence that you discussed that with them. So where it says optional instructions, all you have to do is say something like, I've discussed with my agent, my proxy, and my successor agents, my wishes concerning artificial nutrition and hydration or feeding tubes, and I want them to make all decisions about those measures. That's it. Fill out the rest, self-explanatory. If you want to make organ donations, it's a great form to do it. It's right there. Sign it in front of 2 uninterested witnesses, and we're good to go. And if you don't have a healthcare proxy, and you should, everyone should, you don't even need a lawyer to do it. You could just go back, download it, get 2 uninterested witnesses, and get it done today. You should. But if you don't have a proxy and someone that you love is in a hospital or in a nursing home or in a facility or at home on hospice, and if they don't find a healthcare proxy, family members can make decisions. It's the Family Healthcare Decisions Act. So just know, most people don't know this is in existence, but you do have that. Don't rely on it, get the proxy, but just in case, you do have that. We spoke about the living will. Let's talk about a living trust. I think I only have about 5-ish minutes. Let's talk about a living trust. So what is a trust? Well, a trust is an entity that holds assets. Corporation holds assets, but it's an entity, like an envelope. But a trust is an entity that holds assets. Now, those assets are managed in accordance with a trust agreement. So, someone such as myself, an estate planning attorney, an elder law attorney, will draft this trust agreement and set forth all of the provisions and how those assets are to be managed and what happens with them, who the trustee is, who's going to manage them, and where they're going to go and when. And we do that trust agreement for a specific purpose. We might draft a trust, that trust agreement, it's basically the same thing. We're drafting the parameters of that trust to protect assets for long-term care, or to protect assets for Medicaid, or to protect assets for minor children, Or if there's a disabled child, we'll create a special needs trust. Or we just want to avoid probate, or we want to eliminate estate taxes, or we want to get a life insurance policy out of our taxable estate. That's called an ILIT, I-L-I-T. So many reasons that we will do a living trust. But that trust agreement that the attorney drafts is key. Now, to a trust, there are three individuals involved. The individual that creates the trust is called the creator, the grantor, or settlor. That's the individual that creates the trust. Then there's a trustee that's named in the trust agreement. You can have more than one. You could have co-trustees, like co-executors of a will. So you name who's going to manage it. Now, can it be you? Yes, it could be your trust, and you could actually also be the trustee on many types of trusts. If it's a Medicaid Asset Protection Trust, that's not a great idea. But if it's a revocable trust, if that's appropriate for you, you can be your own trustee. No worries. And you would avoid probate and everything else. Now, what's great about a trust is that, let's say even a revocable living trust, is that, let's say you should become incapacitated, God forbid, in the future, and you have a good power of attorney, everything is wonderful. However, you know, with a trust, it's just so easy. Everything is under one roof, and if should you become incapacitated, and if you were the trustee of your own trust, then you've named a successor or successors. Let's say you have two children. They're going to take over, and they have the rules that you set forth on exactly what you want to have done. And every trust is done for a specific purpose. And it could be multiple ideas and multiple purposes to do a trust, multiple reasons. So for example, if we do that Medicaid Asset Protection Trust, and we want a beneficiary, want to give money to a beneficiary that's disabled, well, we have the assets in the Medicaid Asset Protection Trust, and we say that the beneficiary will be a disabled child, maybe for one of them. Or if we want it to go to children that are minors or grandchildren, well, it'll go, but it'll be in a minors trust. Let's say assets are in the living trust, and you love your daughter and you love your son, but your daughter can't hold on to money, and you want to give her, you love her, but she's going to flit away that money in 2 seconds. So we could create within that Medicaid trust. I'm doing another session, and we're going to focus on different types of trusts. But within that Medicaid trust, we could actually set forth that she's going to get these assets, and it's going to be in a spendthrift trust. Spendthrift, so the monies will be doled out over a period of time, but there for emergencies, or if she needs it, if this is what you want to say, for her health, education, maintenance, and support. So you can do all of that and have multiple reasons and multiple trusts within the one trust. Now, let's just talk about the Medicaid trust for a moment, and then I think my time is going to be up. Now, if we transfer assets into this Medicaid irrevocable trust, it is irrevocable, and typically it's called a MAPT, an M-A-P-T, a Medicaid Asset Protection Trust, and it's there to protect your assets for long-term care. But many times when I tell people, this is an irrevocable trust, they say, oh my God, I hate the word irrevocable. That makes me nervous, and it makes me nervous too. I want to let you know it is deemed an irrevocable trust, but we could draft that trust in a special way to make it 99% sure that you could revoke even that irrevocable trust. We put special provisions in that trust. So don't let the word irrevocable turn you off to something that could really help you. But let's say we have we draft this great irrevocable Medicaid asset protection trust for you. We're protecting the home. We're protecting some of your assets. You should know you should never, ever, ever put retirement accounts directly into a trust. Don't take an IRA and transfer ownership to a trust. I'm sure you guys know why. Uncle Sam will be there with his or her hand out in 2 seconds. When you have assets in an IRA, it's an individual retirement account. When you take those assets out of the individual's name, Uncle Sam in New York State are going to be right there. Never do it. But let's say you put the home and your brokerage account into this Medicaid asset protection trust. In the trust, we could say you get all of the income. If you want to sell the home could be sold in the trust. You could downsize, you could upsize, you could do whatever you want. You could collect rental income. But let's say you bought, and this is a real-life example this week, saw a client, bought his home for $27,000. He put some capital improvements in. His tax basis was $200,000. But now, that home is worth about $1.3 million. Not that unusual because he bought this years ago, 40-plus years ago. So what are we looking at? A big capital gain. If he just gave his home to his children, they will inherit his low tax basis. Later on, when that home is sold, there'll be huge capital gains. By putting it into the trust, it's out of his name for long-term care. It's out of his name for Medicaid. But when he passes away, the basis will move up. There's a basis step up to the market value at the time of death. So 0 capital gains taxes. If he dies when the home is valued $2 million or 2.5, 0 capital gains tax. So we don't have to worry about that. Same thing if he bought Apple stock at the IPO. I always dream about this. It's fun to dream, right? And he paid almost nothing for it, and now it's $5 million. Fun to dream. A basis step up, which is great. So not only do you get that, but if it's your primary residence and you want to downsize, you get the capital gains tax exclusion. Husband and wife get a $500,000 capital gains tax exclusion. So not only does the trust protect the assets, if you just gave it to a child, it's not just the tax issues, but what if a child, gets divorced? And that's part of equitable distribution, or the child becomes incapacitated, or the child has creditors. This happened the week before last with a client of mine, and the home was in jeopardy. You should never have done that. So make sure you have the living trust for that home. Okay, so I am going to go in my next session a little bit about Medicaid, but then I'm going to focus on estate planning and go over details on other types of trusts. So I know I extended my time by 5 minutes, but I hope that's okay. Thank you guys so much for coming out, and enjoy today.